were more polite.
Wait, please, Your Lordship.
Yes, there is a judgment.
I'm sorry. Yeah.
For pronouncement of judgment, item 1.
Under the circumstances, we are of the view that it was not permissible for the learned tribunal to insert only one paragraph, that is paragraph 4 in its order, without any prelude to decision or recording any reason in support of the order. In view of the order dated 24/7/2017 passed by the division bench, the earlier judgment and the order dated 4/7/2014 of the CAT has been wiped out. And therefore, it was incumbent upon the learned CAT to pass a fresh judgment deciding the controversy on merit by furnishing proper reason thereof, which has not been done in the present case. Since the order dated 17/11/2017 was not issued in compliance with the direction issued by the order dated 24/7/2017 passed by this court, hence there is no scope of this court to decide the petition on merits as well. For the reasons stated above, the impugned order dated 17/11/2017 in her considered opinion suffered from serious infirmity, therefore the same is hereby set aside. Taking note of the submission of the respondent's counsel that the date of retirement of her client is approaching fast, we remand the matter to the learned CAT with a direction to rehear the OA number 63/2012 on merit and pass a reasoned order by adhering to the directions contained in the order dated 24/7/2017 as expeditiously as possible, preferably within a period of 6 months from the date of receipt of this order, parties to bear their own costs. Yes.
My lord, may I have your lordship's kind indulgence to mention item number 2 and 3?
Yeah.
My lord, if it is not inconvenient, could it be taken up day after tomorrow? Well, actually, what time this CA matters will be taken up just now in the Supreme Court. We'll do it virtually from High Court, my lord.
Okay.
So day after tomorrow, my lord. I think my learned friend is also tied up in that case.
I am tied up with 2 special bench cases at 10:15. One in court number 2 and one in court number 7. Only single bench, single matters.
Then it will go in the April.
First week, my lord. Lordship can have it on 1st of April, my lord. It's a Monday.
2nd of April, Tuesday.
Okay, okay.
First of second, 22nd April.
22nd.
What?
22nd April.
22nd April. Too many cases, Lordship was pleased to fix on that day of month.
Again, this will again come.
Yes, Lordship. Only the interim order may continue till 22nd.
Yes.
Deeply obliged, Lordship.
At the request of the consultative parties, address these matters on 22nd of April. Interim order pending to continue till next stage.
Deeply.
Hello.
May I please, Lordship, with respect to item number 9, may I please this may be taken on Friday, Lord. I am appealing for the
Special about Friday.
Lordship. This is entirely this is appeal, Lordship.
Listed in next week, in April.
Lordship.
April में third week नहीं कोई date. April 3rd week any date.
Lordship.
Lordship, with the concern of the other side, Lordship, I beg to mention item number 4 and 5, Lordship. Lordship, in this matter, Lordship, I am for the appellant, Lordship, led by Mr. R.P. Kakoti, Senior Advocate, Lordship. He has got some, Lordship, stone pain in today.
I have no objection, my lord, if a date may be fixed.
Yeah,
After 2
any
weeks,
date.
Lordship.
After leave vacation, any date, whichever.
My lord, subject to the convenience of this honorable court, my lord, 22nd, my lord,
22nd already we have fixed the
my lord, 24th,
24th
obliged.
Observe, Lordship.
at the request of the non-consent parties. Just on 24th.
May I please, Lordship?
Yeah.
With the consent of the respondent, I beg to mention item number 6 and 7, Lordship. In this case, Lordship, my senior is out of station. So, my Lord, matter kindly fixed after vacation on 25th April, if possible, Lordship.
25th April.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 8, Your Honor, the daily list, Your Honor. The advocate has some personal difficulties, Your Honor, health issue.
Adjourn.
And in 4 weeks, maybe.
These are old matters. Why are you mentioning?
Your Honor,
19 matters.
Your Honor, the council is unwell, Your Honor. That's all.
Yes.
My lord, I am praying for listing this writ appeal, my lord. This writ appeal, my lord, on the last Thursday, my lord, I had to withdraw, my lord, some mistake was there on my part, my lord. I have refiled it, my lord. Can it be taken up tomorrow, my lord?
April 1st week, any date.
Can it be taken up tomorrow, my lord?
Not
My lord, what
tomorrow.
happened, my lord, the director has passed a consequential
Tomorrow
order,
some
my lord.
difficulty is there, not tomorrow. First week of April.
Now, may I please, Your Lordships, I'm praying for listing of IA civil number 2366/2024 in a PIL dispose of 55/2017, Your Lordship.
When it was disposed of.
It was disposed on 13/12/2022, Your Lordship.
So what's the urgency now? Why you have
Urgency,
moved any IA?
yes, Your Lordship, we have.
For what purpose you have moved IA?
Your Lordship, none of the medical health review board has been constituted, Your Lordship. So we have, in the last order on the 13th, it was said on the,
There is a specific direction of the court to constitute that.
yes, Your Lordship, on the 13th,
File a contempt petition, why IA?
pardon, Your Lordship.
Contempt petition, why IA?
IA has been filed, Your Lordship, already.
IA for what?
IA for,
To initiate contempt proceedings against those persons or what?
no, Lordship, to constitute the medical health review board, Your Lordship, in the 5.
That direction is already there,
Yes, Your Lordship, but it has not been constituted, Your Lordship.
means they have not complied with the order of the court.
No, Lordship,
They have not complied with the order.
no, Lordship, they have not complied with the order.
Then file a contempt petition. Why IA?
Your Lordship, but we have already filed an IA in 19th first.
What my lord is saying that if there is a non-compliance or violation of the court's order,
Yes, sir.
your remedy lies in filing a contempt petition, not an IA in a disposed of matter.
Yeah.
You file a contempt petition.
Quantum. But we have already filed, Your Lordship, the opposite party has also given us a affidavit in reply, Your Lordship.
In the IA.
Yes, Your Lordship.
Now, what directions can be passed? Will the directions be reissued? We cannot reissue it, should not.
But expedite the order, Lordship, at least get us the status, medical status. So,
The court has fixed any time limit to constitute that medical boards or what?
yes, Your Lordship, on the
How-
first 04/2023, Your Lordship, it's been almost 1 year.
The court has fixed the timeline up to which date?
Yes, 01/04/2023, Your Lordship. April, Your Lordship, of
April
2020.
2023.
Yes, Lordship.
And they have not constituted it.
Not yet, Your Lordship.
Then file a contempt petition. It's your allegation is that they would not comply with the order.
Yes, Lordship.
File a contempt petition. Why this IA? For what purpose? What is the prayer in the IA?
IA is to expedite the,
But you have said that the other side has
Yes,
filed
Your
an
Lordship.
affidavit in the IA.
yes,
Was
Your-
the IA ever considered by this bench?
no, Lordship, it was Justice
No,
General.
no, doesn't matter.
Yes,
was
Your
it
Lordship.
before
was
the court?
considered. Yes, Your Lordship.
Okay.
Earlier it was
Oh.
taken into
Yes, Your Lordship.
consideration.
Yes, Lordship. In the last posting date is on February, Your Lordship, February.
27th of, in the first week of April, any day.
First week of April.
Who is for the other side?
The state, Your Lordship, will be the state speaker.
Health Department.
Yes, Your
Please inform them.
Okay, Your Lordship.
In the first week of.
First week of April. Can we have a specific date, Your Lordship?
You ask the date.
Okay. Highly obliged.
May I please, Lordship? Lordship, I beg to mention, item number 10, by taking consent from the other side. Lordship here, my senior will not able to do the matter due to
Adjourn.
his personal
Adjourn.
difficulty, Lordship.
Adjourn.
I am praying for listing of a writ petition, my lords, in a surface side matter, my lords, the physical position was stayed. No, we are for the bank, my lord. We are seeking vacation of that order.
How the bank's writ petition is maintainable?
My lord, the
When the
previous
writ petition of
bench
a
had
private
passed
person
an
is
order.
not maintainable, remedy lies,
No, my lord, this is a pending matter, my lord. And a stay order was passed against us, my lord. It's a pending matter. 27th or 28th, my lord, as your lordship pleases.
in the first week of April.
No, can be on.
Specific date you ask the court master, he'll give you the.
Lovely.
Daily list for orders item 1.
Pursuant to Honorable Court's order, my lord, on 19, my lord, we have already taken steps 20, my lord.
So still the notices have not been served,
Yes, my lord.
was returned undelivered. You have to take fresh steps.
Director of Health. Sir.
Refuse, sir, refuse. Refuse. We'll do it once again.
Dusty, my lord.
Dusty in a contempt,
Yes,
slightly difficult, but why refused? That is better. That's a literature. You can do it. With your content matter, we can inform because they can from here and article taking it. He may appear, he may not appear. This part we can get over. If he's actually not got the notice, then it will be, but if he's got and he's refused, then we can under.
Who is appearing for the health department?
Health has a standing council.
yes, ma'am.
Can you have any one of them
Yes, my after some.
after something?
You please call.
For hearing, item 11 to 13.
So please, your lordship matter will be take up after some time. Senior is Lex in court number 2, lordship.
This is the only matter we have on the board.
Just give me 1 minute, lordship. I have to call.
Call. Call here.
Who is for the health department? Mr. Bora? Health council?
Yes. Make this a lordship.
Lordship, I understand.
Sentence, correct?
Initial entry was not in bedroom code. They're trying to make out of may not be their fault. Whether FIR approval will take some. Don't actually try it.
Lordship, I understand there are hardly any people here, Lordship, but still I have a short, Lordship, can it be taken, can this matter be taken up after some time? Lordship, there's a personal appearance matter going on in put number 2. That
I
might
think-
take some, Lordship,
Person appears. Tenure is appears.
that matter might take some time. And in that matter, Advocate General is also there.
This is the only matter
Lordship,
remaining.
I understand, Lordship.
He can. Take it. इनको ही पहला वाला मैटर में
Who is for the health department?
Lordship, in this matter, from the health,
Just a minute.
Mr. you can take some instructions from the health department.
In respect of another matter.
Another matter.
Where a contempt
yes, yes,
is
Lord.
issued.
yes, Lordship, in the morning, when the mentioning was done,
No, no, right now.
right now. Okay. Item
Okay.
1.
Item 1, you are correct. Item 1.
Yes, sir.
Pursuant to the direction given by this watch. On 19/2/2024. A fresh notice was issued to the sole respondent by registered post AD on 23/2024. Stop, the notice issued to the sole respondent was returned undelivered with postal remark used RTS. Inverted commas, refused RTS. It appears that the same postal remark lacks signature or initial from the concerned postman. Since the respondent is Director Health Services Assam, we deem it appropriate to direct the consent for the
Well, I am appearing.
consent, Mr. B.
Only name may be reflected, my lord, within 2-3 days I will
B.
have.
Gogoi to accept notices on behalf of the sole respondent. Copy of the contempt petition along with the requisite documents be supplied to him during the course of the day.
Then.
Mr. Gogoi may complete his instructions by the next date of hearing. Based on 4th of April, while reflecting name of Mr. B. Gogoi as consent for the respondent.
Obliged, sir.
Item 11 to 13.
Who is there? Mr. Gogoi is there.
You have for the petitioner.
But here I am for the respondent. AG will appear, my lord, he is on legs in, my lord, under court.
AG sought adjournment in earlier matter that in busy
Yes,
or whole day in some matters.
yes, ma'am.
You are
Or my lord,
appearing for the
lazy, my lord, let them.
petitioner. You are appearing for the appellant.
Yes, your
lordship.
So what is your main?
Your lordship, the only, in this issue, your lordship, there was an advertisement. In pursuant to the advertisement, we participated in the selection process. There was a select list drawn
But,
and accordingly we are appointed.
But the learned single judge has taken note of all these facts and come to the conclusion that despite granting opportunity to you on various occasions, you have failed to prove your genuineness regarding genuineness about your documents, which are fabricated, false and everything. And this is not the first time you have approached this court. You have approached many times this
Yes.
court and the court has granted time to you. That grant them opportunity, despite granting opportunity, you fail to satisfy.
Yes, your
Then
lordship.
what remains in the matter?
No, your lordship. There was an RTI filed by us. In that RTI, there was the select list was provided to us. Everything was provided. There was a selection process in persons to which we have been appointed.
I'm
Your
so,
lordship, my senior friend.
I'm so sorry. May I, department.
Yes,
Lordships, in this case, there are 2 sets of appeals.
yes.
Essentially, there are 34 appellants, 17 from Goalpara, 17 from Dibrugarh. And they were all appointed as grade 4 employees in 2005 against vacant and substantive vacancies.
On temporary basis.
We'll see the appointment letter, Lordships.
That's what the finding.
That is why we are before your Lordships. That is why it will be my endeavor to see persuade your lordships that perhaps the finding of the single judge was not correct. So they were basically, they served in since 2005 until the services were terminated in 2019. That is after 14 years of service. All through the service period, they received the regular salary without any break. And the termination of the services have been upheld by the learned single judge. Now the state case is that these appointments were fake.
Yes.
Which of course the High Court, the learned single judge didn't hold it to be fake. Didn't hold, but it said it is illegal.
Just
Yes.
come to
Lordship is having Narayan Rabha's appeal. Narayan Rabha's appeal.
this appeal, Lumbit Kumar.
Lordship will,
The judgment is the common judgment.
the pagination is different.
The common judgment is there.
Yes, yes.
Then come to the
Pagination would be different.
internal page of the judgment. 101.
101 lordships.
Yes.
Para lordships. Appeal.
It's
Para
got
90.
90.
Para 90.
Yes, lordships.
Page 15.
Yes. From the above analysis.
Yes.
Yes. From the above analysis of the facts and relevant provisions of law, it would be seen that the Health Department of the Government of Assam had carried out a detailed fact-finding inquiry as regards the genuineness of the appointment of the petitioners. The petitioners have been afforded opportunities to appear before the screening committee on various occasions, and the petitioners have been asked to prove the genuineness of their appointments. Not only the petitioners failed before the screening committee to prove their genuineness, in spite of deficiencies pointed out, even before this court, the petitioners could not show that the appointments were made in terms of the provisions of the rules of 1997, or were made with the approval of the then existing SLEC, or that the appointments were made not during the ban period, or that were Finance Department SI's approval prior to their appointments. This is what lordships is emphasizing. Yes, yes.
Then
The next paragraph is wrong. That was one.
yeah, let's read.
Yes.
Then find out how it
The
is.
only plea which has been taken in the replies to the show cause notice was that the petitioners were duly appointed against the vacant sanctioned posts and were regularly receiving salaries without any objection, and the transfer orders of the petitioners also show that the Director of Health Services knew very well that the petitioners were appointed. It was also the argument of the learned counsel for the petitioners by drawing the attention of this court to the office memorandum dated 4/7/2005 and 14/7/2005 that the petitioners being disbursed the salaries by the respondent authorities meant that the petitioners' appointments were made either with due approval of the SLEC or with the approval of the Finance SIU department, inasmuch as without the approval number, the salaries of the petitioners could not have been released. It is the opinion of this court that the said contentions of the petitioners are totally misconceived, inasmuch as if the appointments of the petitioners were made dehors the rules of 1997 or during the ban period or without SLEC or SIU approval, as the case may be, the illegality in their appointment do not get legalized in view of the complicity of the then Joint Director of Health Services, the Director of Health Services Assam, and the Treasury officers who were releasing salaries, who with impunity resorted to illegalities, nepotism, and favoritism by violating the provisions of the rules of 1997, the prevailing executive instructions, as well as the rights of other eligible candidates under Article 14 and 16 of the Constitution.
Just a minute.
Yes.
Even the director. Yes,
Shall I read on or not?
please continue.
In the backdrop of the above, this court is therefore of the opinion that the question of issuance of a writ in the nature of certiorari in the present case for setting aside the impugned removal orders do not arise, inasmuch as all the appointments of the petitioners were illegal appointments and no sanctity in the eyes of law, for which they are non-est. Accordingly, this court finds no merit in this batch of writ petition, and consequently all the writ petitions must fail. Before parting with the records, this court finds it relevant to observe that the public power to make appointments of public posts is conferred for public good. The power is given to the officer concerned by the government in trust, and it shall be used and not abused. If the trust is belied, the protection conferred upon a government servant stands denuded. The answerability and accountability is then individual of the officer. The government is duty bound to make appropriate civil criminal action against the officer. The illegality in the appointment is not one-way street. If there was someone willing to pay a price for the job, there was another waiting to take advantage of the same by fixing the price. It is not without reason that the appointments relate to grade 4 post, the standard by which the government professes to act in the same standard by which the actions shall be judged. Therefore, whenever the government terminates an appointment illegal, it is the constitutional duty of the government to simultaneously take action against the officials who belie the trust of the government. Accordingly, this court therefore directs as follows. The government officials who were responsible in facilitating such illegal appointments and the government officials who resorted to pay salaries to the petitioners without taking into account as to whether the petitioners' appointments had the SLEC or SIU approval are required to be made accountable, as they have resorted to actions which have resulted in breaking the public trust reposed upon them. A constitutional duty is cast upon the state, therefore, to take actions against the officials who have belied the trust of the government. This court therefore directs the chief secretary.
So the court has granted a little bit relief to the relaxation in age if you apply in the
Yes,
pursuant to
yes.
the fresh and no recovery of the salary already
Yes,
paid.
yes.
Now, Mr. Counsel, the whole controversy lies in the facts only. You have to prove your appointment genuine. And now it is settled that if the appointments are illegal, then certainly no writ can be issued.
Therefore, Lordship will have to look into the facts.
Yes, that's right.
So therefore, I just wanted to place the facts.
Mr. Counsel,
Fine.
pursuant to the direction given by this court, any proceedings were initiated against those government officials.
In the meantime, these appeals have come up, my lord, probably.
In this appeal, there is no stay,
Fine.
except this, that the 17 posts or 34 posts shall not be filled up.
Lordship.
This is the only stay.
My lord.
Why you have not taken any action against these things? Only because this pendency of the appeal is there.
No, my lord, I'm not making my submission on instruction. I'll have to take the inspection.
The state has not filed any appeal against this observation.
No, madam.
Even those officers have not come.
No.
So there is no restriction.
No.
as such.
Just
Have you initiated anything? Nothing.
that part, my lord, I cannot say. That is it. I communicated to the director so that, my lord, it can be
But
placed.
in if you remember correctly, in few of the cases of illegality of medical department,
Yes.
you have
In fact,
taken action
one-
against the directors.
Yes, my
Additional.
lord. In fact, FIR was lost, my lord. Those criminal cases are pending, my lord. All this, my lord, at that time, whoever was the director against him, my lord, including the joint directors, my lord.
Apart from criminal proceedings, any departmental proceedings?
My lord, by now, my lord, all have retired. Because, my lord, 2005 and all, my lord, those.
I know all the.
Probably, my lord, I
Responsible.
can't say, my lord, that without instruction, it will be difficult.
What is the status of the
But, my
criminal?
lord, the department lost the FIR.
What is
Lost
the
FIR.
status of the criminal cases?
Have you lost any criminal cases or not?
My lord, we have lost the FIR.
In this matter?
Yes, my lord, in this particular issue only, my lord, not on after the order. Before the order itself, my lord, FIR was lost.
Even before.
Before this, my lord, order was passed, FIR was lost.
Maybe we had overthink. Health worker, surveillance worker, with malaria workers.
Yes, ma'am. In fact, my lord, one of the matter was even dealt with by a lot of people, which has been upheld by the division bench, because relating to malaria department.
That matter was put to challenge.
Yes, it was upheld by the division bench. finally.
Their consideration is substantially premium.
In this matter, Mr. Advocate General is.
My lord, yes.
Yeah.
Yes.
I must say one thing, Lordship. We must clarify one thing. The paragraphs that I read, there were 12 writ petitions that were clubbed together and heard. It may not be relevant to my case. My case, the High Court very clearly says that there has been a selection process. No, so therefore, please do not bracket me in that.
Certainly.
So therefore,
Here the appeal separately.
yes, no, so therefore, this common judgment is quad 12. So there are actually, I must say, I am only for those where the High Court itself says that there is a selection process.
That's right. You mean to say that these, whatever the findings recorded by the learned single judge in those 12 writ petitions may not be relevant for your.
I am so grateful, Lordship. I am so grateful.
Fine.
But the
So therefore,
discussion
maybe,
have been made separately for all the cases. If you read the judgment,
yes,
the case-wise discussion has been made. Thereafter, the conclusion part is a common that we are clear that it may not, your submission is that it may not be fitting into your case.
I am
Facts
so
of your
grateful.
case. But the discussion is a separate one. So for your case is concerned.
Each and every case, the learned single judge has
so
discussed.
therefore,
the
let me
facts
demonstrate the
and
facts.
the merits of each case separately and then pass this common.
So therefore, let me demonstrate the facts. And then Lordship will see the findings for my case.
That's right.
Well, Lordships, then Lordship will kindly come to page
Now,
160.
another problem is that Mr. Sekia, learned advocate general, he is to argue in this matter.
Because on last occasion, the same submission was made.
The same submission now will.
May I just request that
will,
I may come to
whatever
claim and
we
note
fix
it
a
down?
date with this understanding that on that date, if Mr. Advocate General is not available, you must argue on
My
any
lord,
other
in fact,
consent. You
my lord,
prepare your alternate arrangement. We are not
before
going
the
to
learned
adjourn
single
on
judge,
this
I
matter.
argued, my lord, I am acquainted with the.
Yes, certainly, learned Advocate General has to appear in many cases.
Lordship, I
And
understand.
not possible for him to each and appear each
My-
and every case. Therefore,
will,
you
my-
make your alternate arrangement since you are also representing the state.
Lordship.
It can't be the.
Because paid in
21st
Yes.
fixed position only.
23rd. তোমার উপর কাটা। 23rd में বন্ধ হবে। 23rd में বন্ধ।
হ্যাঁ?
Present of the advocate,
কোন দিন আছে?
23rd में।
learned counsel, Mr. B. Gogoi, appearing for the health department has submitted that. Advocate General is to
নিয়ে তো, নিয়ে।
review the matter. And since he is already arguing a fixed matter in another bench,
21st of the
some other date may be fixed. Stop
21st of the
taking into consideration the above fact. Deem it appropriate to miss this matter during the Wednesday and
Thursday and Tuesday.
Thursday and Tuesday.
21st.
This matter on 25th of April 2000.
Can it be 21st of May? Because it's convenient, otherwise again they will.
Beyond that, yes,
Seeking for which date you want?
21st May, Lordship.
21st May.
Because I believe April, there's a long weekend, a lot of holidays. If it is convenient for them.
The holidays are going to be up to 17th only. And we are fixing it on 24th of April,
My lord,
25th of April.
my lord, we will be.
Thereafter, there are no
Let
holidays.
it be 21st May, Lord.
No, in a way, we want to fix it on a hearing day.
21st May, the hearing, I believe.
Yes.
Wednesday,
Tuesday.
Tuesday, Lordships.
It's on 21st of May, 2024. On that day, learned counsel appearing for the, and Mr. B. Gogoi, learned counsel appearing for the health department may apprise this court about the proceedings initiated by the court pursuant to the direction contained in para number 93 of the impugned judgment.
Standing down 21st May.
Yes,
we
sir,
got
it will be reflected, I will.
Certainly.
I will.
There is no question of adjournment on this ground only.
Lordship.
Make your alternate arrangement.
Mr. Gogoi, try to bring that division bench order.
Yes, my lord, I will.
Whatever the judgments you are relying on,
Grateful.
Interim order.
Interim order may continue, Lord.
is it limited?
No, well, it's fine. It was till next one. No, it was not.
On the last occasion, it was.
Till the next returnable date, it was.
Returnable day first.
It's okay. Interim order, if any, to continue till next date.
Yeah. Till next returnable date, 7 and post held by the post.
Till next date.
I am grateful, Lord.
God bless you.
Grateful.